flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. On the Texas flag, I pledge allegiance to the Texas, one state, under God, one indivisible.
All right, Mr. Brundrett, this in a prayer.
Please join me as I pray. Father, as always, we're thankful for the blessings of this new day. And as always, Lord, the great privilege of being in this country and this state and these communities. And Lord, we humble ourselves before you. And I'm recall of Proverbs scripture in I think chapter 3, verse 5. It says, trust in the Lord with all thy heart and lean not to thine own understanding, but acknowledge him in all ways and he will direct your path. And Lord, we live in a complex, tedious world, and we need to know what the truth is and which direction to go and what to follow. And there are a lot of voices out there, but your word tells us that we're to trust in you. So we place this meeting in your hands today, Lord. We pray that you watch over these commissioners, you direct their thoughts and actions so that the result of these actions today will benefit the citizens of this county. We trust you, Lord, and we say we love you. In Jesus' name, amen.
Amen. Roll call.
Commissioner Cheney,
Here.
Commissioner Casterline,
Here.
Commissioner Russo. Here. Commissioner Dupnick,
Here.
Judge Garza.
Here, we've got a full court. And just Colin, our screens still aren't on.
Says no signal.
Looks like it's. No.
Still saying no signal.
Now.
Now. Ours is, but
But
his isn't.
ours aren't over here.
It's okay.
Something like.
Yeah, I had too much tear.
I think that's what it's.
Okay.
Come on down the line,
Colin. There's.
No, no,
Oh, it's on.
we're on now. Must have been on the delay.
All right, we're gonna move on to citizens to be heard. County clerk, nothing? All right, cool. Presentations and proclamations, item number 1. We have a presentation from the Coastal Bend Wellness Foundation addressing substance use and opioid use disorder in rural communities of the Coastal Bend. Mr. Delegate, how do you say that?
Delgadillo.
Delgadito. All right, cool. Good morning.
Good morning, ladies and gentlemen. My name is Aaron Delgadillo. I'm the Rural Outreach Specialist with the Coastal Bend Wellness Foundation. And I work specifically for the project REACH, which is the Rural Education, Awareness, Community Health. And pretty much my job is to go out to the rural communities and talk about substance abuse issues that are plaguing those communities and how we are trying to address the opiate use that's happening in this area of the world. And we're also trying to become the intermediaries to solicit, not only help out the communities, but also help out the counties by establishing referral networks in order for us to be able to provide services for your community or your citizens. Well, my job here today is pretty much to give a presentation about what we're doing. For example, right now, my job is to go out to be able to explain what substance abuse is, how is it affecting the community, how it's doing long-term impact on both social and financial budgets, right? We know that substance abuse does harm the community and tends to take a lot more taxes that gets put into the community. So what we're trying to establish is not only solicit that and be that help for the people and the citizens that are out there, in order for them to know that we exist, we are providing services, we could help them get those services, and we could get them to a place where they could be sober and be clean and be a productive member of society. Right now, we are working with other agencies. I know I am partaking with the Children's Coalition, ladies. That's one of the programs that we're working with. But the reason I'm here is because we're trying to work with the county, with county services, like the health department, the sheriff department, police, and indigent health services in order to be able to better provide services for your community and also for your awareness, because I've been going to some counties and they are not aware that we exist and that we're providing these services. So it's the better way is you have a tool at your disposal, but if you don't know you don't have it, how can you use it? Correct? So that's why I'm going out here to present what we're doing for you guys and how we would like to work forward with you guys. So I did give in my presentation, I believe, some brochures and information. And we would like to someday in the future, participate in a MOU, a memorandum of understanding between our program and the county. So right now, we just brought a rough draft and it's to be fixed and amended with the county attorney in order to be able to provide those services to more suit your needs to your county. Our program is free. It's been free. We're not charging you nothing. We're doing this on a grant from federal money that we have and we're working. Again, this is a service that is completely free for your citizens. But if your citizens don't know that we exist, how can we help them? And I'm open for questions.
Mr. Delgadillo, I would suggest two things. Our treasurer is here, Ms. Alma Cartwright, and she's over the Indigent Health Department. And we have addressed the opioid and substance abuse disorder in court before. And then also Laura Rios is our juvenile case manager, and she would be a very good person to talk to. And so I would just suggest that you might especially give a card to Ms. Cartwright, and I can pass on your information to Judge Dupnick or to Laura Rios or Judge McGinnis, who oversee the case management.
Okay.
But thank you for making us aware of this. I did not know that your organization existed and had this program.
Yes, ma'am. That's the whole reason I'm doing this out here today.
Okay.
And I believe we did speak a while back ago.
Oh, you did? Okay, good.
Yes, I'm trying to link up with as many as I can. I know with the county sheriff, I did some Narcan training a while back. And he participated and I explained what substance abuse is and how it works. And again, we're just trying to educate, because the more people are educated about how this works, the more better help we could provide to those citizens.
Have you talked with Patricia Arnold with the Aransas County Medical Services?
That's one of the people I'm looking to speak to
Okay, good.
forward.
Thank you.
All right, thank you.
That's it. That's
Appreciate
it. Thank you very much, sir.
Move on to item number 2, presentation from the Children's Coalition of Aransas County. Good morning, Ms. Nielsen and Ms. Glidden.
I'm not going to be up here very long because Diane Nilsson's going to be the expert here. But one of my greatest joys of working for the county and being a part of Texana AgriLife is getting to work with and be on the board of the Children's Coalition of Aransas County. And I'm very proud of the work that we do and the services that we're providing the children and families here. And the best person to describe what we're doing and to go a little bit more in depth to kind of give you an update on where we are is Diane Nielsen, our executive director. I do have some copies for you. Failed to make 6, so I'll bring another set for you later today.
Thank you. Good morning.
Morning.
So just a little update. Some of you know about the Children's Coalition. For some of you, I think it may be new. Let me see if I can use this clicker. Maybe not. Yes, I can. Okay. Children's Coalition of Aransas County has been serving children and families in our community since 2017. We were born of Hurricane Harvey when we started Camp Harvey. That was in the fall of 2017. And Camp Harvey was a 3-week-long emergency childcare program that provided care for 52 young children in our community while their families were in the very beginning stages of recovery from the hurricane. When that was over, we realized that there were still some needs in our community. Our community faces some pretty serious challenges. These are some images of some of the homes of the families that we are currently serving. According to the Annie E. Casey Foundation's Kid Count Data Center, currently 32.1% of Aransas County children live at or below the federal poverty level. And Aransas County ranks in the lowest 10% in the state for children's economic well-being. Children living in these homes.
Ma'am,
Yes, sir.
let me ask you a question. The 10%, you're saying that we're in the, as far as being able to service the children or where we are, we're in the top percentage or we're in the lowest?
We're in the lowest. We're in the
Yeah,
lowest
okay, I thought-
10%
I
in
thought
terms
that was
of
a mistake.
our highest in terms of poverty,
Yes.
yeah.
okay.
right? The child abuse rate, and this is just staggering to me. The child abuse rate in Aransas County is 2.5 times the state average, again, according to the Annie E. Casey Foundation Kids Count Data Center. So we see children who are dealing with verbal abuse, physical abuse, and sexual abuse. We had a little 14-year-old girl in our office last week fleeing from an abusive situation at home, and it happens a lot. Prior to October 27th, 2022, there were enough legally operating childcare spaces in Aransas County to meet 11% of the need. Children's Coalition is a faith-based organization doing what we can to share the love of Christ with our community. We envision a community in which every child will have a safe, healthy, and happy childhood. So on October 27th, 2022, CCAC opened the Coastal Bend Child Development Center, and this created 93 more regulated childcare spaces for children and families in Aransas County. That moved the needle a little bit. We're able to meet about 20% of the need now, but it's, better than it was. It's a step in the right direction. Providing high quality early learning and care for children between 6 weeks and 12 years of age, Monday through Friday, all year round. %64% of the children who attend the CCAC Coastal Bend Child Development Center come from low-income households.
Where is this located?
It's at 922 Highway 35 South.
Okay.
You've been there, Jack.
I know it.
Yeah.
I just, but the audience doesn't know.
Research shows that quality birth to 5 early childhood education delivers the greatest return on investment. And that's one of the handouts that I have for you is from the Heckman Foundation as a source of this data. Every dollar invested in high quality birth to 5 early childhood education for disadvantaged children delivers a 13% annual ROI. This is significantly higher than the 7 to 10% ROI delivered by preschool alone. So we as a society, we as a state, focus a lot on elementary education, on public schools, on pre-K. According to the Heckman Foundation, that's too late. We need to start at birth. Quality care and learning provided by 5 days a week gives parents the time to enter the workforce and build skills and advance careers and income. High quality childcare programs pay for themselves, again, according to the Heckman equation, within 5 years, based on the income gains from the parents who enter the workforce. And we have seen family after family that we've been serving through the years who've been struggling, who finally have been able to get back to work, and it's life-changing for them. Since October 2022, through this Child Development Center, CCAC has created 25 new local jobs. These jobs put more than $55,000 a month into the local economy. We provide an emergency food pantry for families in need. The annual economic impact of this program is about, or not annual, the monthly income is $1,500 a month. We work in partnership with Good Samaritan and we deliver groceries once a week for families who lack transportation. Our diaper pantry. We always need more diaper donations, y'all, always. Our diaper pantry serves approximately 90 families a month. And the monthly economic impact of that is more than $1,000. And we have a children's clothes closet. We offer gently used children's clothing from newborn through children's size 18. The monthly economic impact of that closet is approximately $2,600. And we impact the economy by providing workforce training services to early childhood professionals. We host an annual early childhood conference coming up in February. This brings about 250 early educators together, and we do partner with Rockport Fulton ISD to sponsor and present this training opportunity. And we provide 120 clock hours of training locally for childcare professionals who want to earn a nationally recognized credential called the CDA credential. With this training course is a $400 value and it's offered at no charge to employees at the CCAC Coastal Bend Child Development Center so that they can get that head start on education about child development. And it's also tied to a career ladder so that staff members step up and make more money when they're in the course and after they complete it. Through these and all the other services we offer, our impact on the community, economy in the community is greater than $725,000 a year, which kind of startled me when I started doing this data dive. While we receive a modest amount of income from subsidies from Texas Workforce for childcare, that does not begin to cover the full cost of quality care. The center operates at a deficit every month. We depend entirely on grants, donations, fundraising activities to provide the funding necessary to do the work that we do. So the recently approved Texas Constitution Amendment Proposition 2 amended the Constitution to allow counties or municipalities to authorize a property tax exemption on all or part of the appraised value of the real property used to house child care facilities. We're paying a whole lot of money in taxes on that building. And so this would be very helpful, not only to CCAC, but to the other child care centers in the community who provide care for low-income children, if you would consider ways to implement this exemption in our county. Thank you for your support.
Diane, do you want to mention Friday?
Yes, that's it.
Okay.
And so for those of you that don't know, and those of you that do, we're excited to come see y'all on Friday. Friday is our annual big fundraiser. We have a band, dinner, dancing at Fulton Convention Center. If you are interested in coming and do not have your tickets yet, you do not want to miss out. You can find our tickets on Eventbrite by looking up Children's Coalition Blazing Trails for Kids, or you can call our office and we can get you some tickets for your family and friends that want to come out. Or go to the website. There is a link on our Children's Coalition website as well, which if you haven't been to our website, it's pretty swanky and has lots of information about what we do as well. Any other questions for commissioners and judges today?
www.childrenscoalitionac.org. AC for Ramsey County.
Yes. All right. And
Yes. Oh, you got to come up to the microphone. Yeah.
Can I state my name?
No. Here.
Okay. Do y'all accept gently used clothes and toys?
Yes.
Yes. Okay, and you just bring it to your.
On children's sizes only, we don't do adult.
Okay, perfect.
and we accept food and we accept diapers as well.
Thank you.
Preferably new, yeah, not used. Yeah, not used. Those go in the trash, y'all. All right, thank you.
I
Thank you
appreciate it.
for the
Thank you.
work you do.
Thank you. All right, item number 3, issuance of proclamation P-29-2023, proclaiming Steve Russell as Aransas County Artist Laureate. Did I say that right? Laureate? All right.
Laureate, yes.
Ms. Day, I believe you're going to read the proclamation.
I am
Can I have
Jennifer
a
Day.
second motion for the motion?
I'll second that.
I didn't know we had to.
Okay.
Okay, thank you.
Jennifer Day, Rockport Cultural Arts District. And I want to give credit where credit's due. Judge, thank you for this recommendation.
Oh, thank you.
Recognizing Rockport artist Steve Russell as Aransas County Artist Laureate. Whereas Steve Russell epitomizes, illuminates the Texas Gulf Coast School of Art, capturing the beloved landscapes, wildlife, people, and history of South Texas, often overlooked by academic critics and urban sensibilities. A lifelong resident of Rockport, he was instrumental in starting the Rockport Art Association, which later became the Rockport Center for the Arts and the Rockport Art Festival in the 1960s. He has been a pillar of that institution, serving as board president, supporting and raising money for the continuation over 60 years. He has instilled artistic excellence in hundreds of art students, patrons, and artists through his teaching, lectures, and presentation. Whereas Steve Russell has worked alongside artists like Jack Cowan, Kent Olberg, and others to promote and support environmental and conservation causes, donating art for groups like Coastal Conservation Association and Ducks Unlimited. This artistic activism is a hallmark of Rockport's creative community, helping to save everything from redfish to estuaries, all of which Russell has captured and immortalized in his art. He continues to be respected and revered, a revered figure for many long time and beginning artists through South and Central Texas, passing on traditions such as plein air painting. Primarily self-taught, he studied with many great artists, including notably William Briggle, who was influential in his artistic development. He has mastered many forms of painting as well as other three-dimensional art. He is currently creating a major public art sculpture, Cultural Interface, sponsored by the Rockport Cultural Arts District and the Aransas County Navigation District. Whereas Steve Russell has been a catalyst and linchpin for the art colony, named one of the top 10 coastal art colonies in the U.S. He is featured as the cover artist for a Texas A&M Press History of the Art Community published in the spring of 2002 through 2022. The story of the Rockport Fulton Art Colony, how a Texas coastal town became an art enclave, highlights Steve Russell's role over 6 decades as an inspirational figure, teacher, and mentor. As historian William Reeves noted in the book's foreword, Russell and other accomplished Texas artists created and popularized a distinctive regional art genre. John Osp, gallery director and adjunct professor for the College of Art and Design at Rochester Institute of Technology, has noted, "No artist's roots go deeper or branches spread wider." Displaying a masterful impressionistic style, Russell is none other than the quintessential Rockport artist. And whereas Steve Russell's work is widely collected through the U.S., displaying the highest artistic excellence in depicting an often overlooked part of the state. Now, therefore, Aransas County recognizes Rockport artist Steve Russell as Aransas County Artist Laureate.
Oh, yes.
Are we ready for photo op?
Well, let's go and do a roll call.
Oh, okay, I'm sorry.
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo.
Aye.
Commissioner Dupnick.
Aye.
Judge Garza.
Aye. Passes 5-0. All right.
Photo op. Now we're
Photo
ready.
op.
Credit to the community.
Didn't get Cheryl. to come up here,
If you'd like to hold the proclamation for the.
We haven't signed it.
Oh, yeah. Well, yeah. We. You are ready. Thank you. I appreciate it. All right, thank you so much. Gonna move on to the consent agenda.
I move we approve the consent agenda, but pull out item number 8. That was in there.
Is it number 6?
6.
Oh, sorry, number 6, which is in there about the coastal bend bays and estuaries.
Do I have a second?
Second.
All right. Do
Commissioner
we-
Cheney,
Question before we vote, why are we pulling that out?
So,
We're going to discuss it separately.
Okay, all right. Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
aye, passes 5-0. We'll move on to item number 6 for discussion.
I move we receive and record the follow-up response from Adrian Hilme of Coastal Bend Bays and Estuaries Program to the question raised during the 11/13/2023 Commissioners Court meeting. And Colin, if you could pull that up, please.
Second.
Got the motion, got a second?
I just wanted to share this information with the court and with the public. When Adrian came to our meeting 2 weeks ago, there were 1 or 2 questions that he wanted to do a little more research and then bring back some evidence. He emailed it to me, but I wanted some way to get it out in public. So this is the information. It was in our packet that was distributed along with the agenda. And if you'd like a copy of it, if you could let Tracy know in the judge's office, she can get you the information. But basically, he says, thank you again for the opportunity to speak. I wanted to follow up on the question regarding mercury concentrations. I presented information about mercury concentrations from 2 different sources, groundwater and oyster tissue. Concentrations found in each source should not be compared to one another since the regulations for drinking water and shellfish consumption are different. Mercury concentrations in groundwater were below the detection limit of the analysis conducted. That's 1/10,000th milligram per liter, which is well below the EPA standard maximum contaminant level for drinking water of 2/1000th milligrams per liter. This is encouraging as the data do not suggest mercury is leaking out of the settling ponds via groundwater, which would pose a direct risk to residents with drinking water wells. And thirdly, regarding mercury concentrations in oyster tissue though preliminary, the mercury concentrations in samples taken from Port Bay fall within the range found throughout other Texas bays, suggesting that Port Bay hasn't experienced a significant contamination event, that is Hurricane Harvey, which would cause or justify changes to oyster harvesting or consumption advisories. The highest concentration found at Site 3 of approximately 15/100th milligram per kilogram, which is still well within the safe seafood consumption recommendations provided by the FDA. And then below is a table from the FDA website, which can be found, and he gave a couple of links. And then you can see the table on screen. Weekly fish servings, if you have 0, the screening value is greater than 0.4600. If you have 1, the screening value would be equal to or less than 0.4600. 2 weekly servings equal to or less than 0.2300. And 3 weekly servings equal to or less than 0.1500. And that's the follow-up.
All right. Go and vote.
Commissioner Cheney,
Aye.
Commissioner Castelline.
Aye.
Commissioner Russo.
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
All right, passes 5-0. Going to move on to item number 7.
I move we approve the third quarter report for the Texas Maritime Museum.
Second.
Got a motion, got a second? Good morning, Tom. You want to come up to the podium?
Judge Garza, Commissioners, good morning. I'm Tom Rodino. I'm filling in as the Executive Director for the Texas Maritime Museum. Dr. Justin Parkoff left the museum a few weeks ago. I don't have his qualifications, so you're not going to get a Texas history lesson from me. I've only been on the board for a few months. But I did want to point out two people that most of you probably already know. Shelley Nossman, who is the Education Director for the museum and has been there about 3 years. And then Ashley Papriza, who has been with us for about 3 months as the executive assistant. And of course, you know, she was with the appraisal district for 10 years before joining us, and she was at an accounting firm for 10 years before that. So she is now the brains behind the numbers you're going to see here, because you don't want to depend on me to do it. But I did want to make sure that everybody knew who they were, because they really are critical to the success of the museum. Let's see, where's my, do I do this? Hey, there we go. All right, I said no history lesson, but there's an example of the artwork that has recently been available at the museum. They're going to see more of that coming up as we start looking at how to change out some of the exhibits, take advantage of some of the things that are in storage. The monthly breakdown in the attendance, and I don't think there's any real surprises in that distribution. It links to peaks in the events like spring break, summer beach season, warm weather holidays. But I think the thing that's significant to note as we go through all of these is that what we're seeing is increases in the numbers overall. A couple of months where the change from year to year was slightly less, but if you look at that number up in the upper right corner, you'll see that there's increases overall. And this shows the trend. For we all know what happened in 2020. It's been climbing back ever since, but we're on track to have record attendance at the museum this year. Push the right button. There we go. Shows where most of our visitors come from. When we track that information coming in, San Antonio, Austin, Dallas, Houston get picked out, local gets picked out. That one down at the bottom there, blue, that says other, we're not really breaking that down any further than that. So one of the things we want to look at is what's in there. Is it other Texas? And is it people coming from outside Texas as well? More than half of the visitors had overnight stays. And that's another area with a substantial gain. If you look down at the numbers compared to second quarter last year. This is how we've applied the hotel occupancy tax funds that the county has authorized for the museum. Some of the major developments that have supported visitor growth are shown there. A couple of things that we've done to try to get a greater level of awareness out there. The new updated website, the publicity that we've had from the Rockport pilot and others on the fact that there's no longer an entrance fee. Probably half of the inquiries that we get by telephone want to know the hours of operation and whether or not there's an entrance fee. So the word is starting to get out. We're going to try to make sure it continues to get up. Big part of that is, come here we go. Am I going in the right direction? All right. Oops. Okay, these are some of the programs, and that's why I have Shelley here. There are so many different programs that she has going, and she's got plans for the future. And notice they're mainly, they're showing children. But when those children come into the museum, they're not coming alone. They're coming with parents, they're coming with grandparents, they're coming with people who are visiting from outside the area. And so each year, these programs have grown. And the one that's not shown on there was one that you'll see in the next report in October. We had over 1,100 people come through for the Halloween event. So those numbers are continuing to grow. Last thing I wanted to point out was that the speaker program that's going to resume here soon. But one last year, if you missed this one, Texas Navy Day, make a note of that for next year because it was a fantastic presentation. Had 3 of the Texas Navy admirals in the room at the same time, and a lot of historical artifacts the museum has that are not always on display will be on display for that day. So if you have any questions that I can dodge, I have them here.
I'd just like to mention something. You didn't mention too much about yourself, but you do have tremendous qualifications, and they're very happy to have you at the Maritime Museum as a retired captain of the U.S. Coast Guard with lots of connections to the port industry. And so we're glad to have you there, Tom. And then also you might tell them about the fundraiser that the museum has coming up, or you might allow someone else to.
Well, and that what Pat's referring to there is the annual Christmas Gala, which is December 8th from 7 until 10 p.m. I didn't think to bring a copy of the flyer, but we've tried to get that word out to anybody that's interested in coming. It's a great program to support if you're interested in tickets or being a sponsor or just making a donation to the museum. You can look at that information on the website or catch one of us and we'll send it to you here shortly.
All right. I appreciate it. Good
Sure.
job.
Thank you.
Thank you so
Thank you.
much.
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo,
Hi.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye. Passes 5-0. So item number 8, I was going to strike it, but I'm going to leave it on. We're not going to take any action on it, but I do want to open the floor for discussion since y'all are here. So I will entertain a motion to discuss.
I move to discuss the proposed revision of Order O27-2023, an order of Commissioners Court of the County of Aransas, replacing Order O12-2021, entitled Regulations for the Cutting of Live Oak Trees in the Unincorporated Areas of Aransas County, to retitle the order Regulations for the Removal or Clear Cutting of Live Oak Trees in the Unincorporated Areas of Aransas County, to amend definitions and procedures, to provide for severability, repealer, and savings, and to establish an effective date. And we'll just discuss.
I got a second.
Second.
All right. We got a second. All right. So this order, there was a mix up in what was posted. I guess there's some more revisions that were submitted last minute. So would you like to speak on those revisions? And good morning, by the way.
Debbie Griffith, Chair of the Tree Committee. I have here Shelley Steckler as well. The remaining revisions, one, I'm going off the top of my head now since I didn't bring it with me.
I'm sorry.
That's okay.
Do you want-
Sure.
And then you can give it back.
Yeah. Yeah, the tree committee felt that it was important in the definitions when it talks about development, pre-development, construction activities to emphasize that the critical root zone be protected during those activities. And I know that legal thought, I think, a little bit differently about that, but we all felt when we met again that that was something that was important because we know it gives you another avenue to hold someone accountable. There's a couple of places like at Big Shell where the trees would be living still if they had protected it and not covered up the surface. So we felt it important to emphasize that. And so that's on just those two definitions. And then on page 5, in talking about the tree plan, in one discussion with environmental department and such, we felt that it important to add in there about any activities planned in the near future. So you may be developing the land and think that you're going to put a building here, but you know, in the next year or once you get through with that, you're going to go further. And so we just added that in, or planned in the near future. We edited on about the meetings and duties of the tree committee to make it more passive and flexible. Instead of saying environmental health will provide an annual report on as needed basis or an annual report to the committee, we just changed it to say the committee will request periodic activity reports from environmental on an as needed basis in order to understand the utilization, compliance, and identify any trends. Because without that information, it's very difficult to annually review the tree ordinance. And we don't want to wait and just do that in 1 year. So we just would like that ability to ask it on as needed basis for information that tells us kind of what's going on, what size properties, where are they, who is violating the order, et cetera. And so we just made it more passive instead of a must do annually. And then there was a renumbering of some of the sections that had been out of order. Previously, a couple numbers were skipped and we did that. And then because there is a reinspection fee now, nowhere in the tree order did it mention reinspection. So we added under mitigation replacement trees, just a sentence where it talked about replaced trees need to live 3 years. We just added at the bottom, a reinspection by environmental health will be provided periodically during the 3 years to validate the health of the replaced trees. Because otherwise, there was a fee, but it didn't mention it anywhere in the order. And I believe that was it. We're ready to move forward and implement this and communicate it and work with environmental to update their documents and get it to move forward.
All right.
So if you had the ability to approve it today, that would be great.
We don't.
Oh.
We'll put it on the next meeting.
Okay.
Yeah.
Do you have any questions?
One of the things that I found, I thought it was listed in the changes of list. It stated or alluded that the tree committee was an advisory to the commissioners court. I don't believe that to be the fact. I believe you're an advisory board to the director of environmental health.
Do you know where it says that?
Page 6, section 5.
It might be something that we overlooked that was an edit from legal. Where is it?
5, section.
That was not an edit from
5A.
legal.
5A.
I'm sorry, what?
It has always been in the previous order in 2021 that the tree committee does advise commissioners court on the tree order. That has always been the case. There was no edit from me on that. I would like to give the court the quick overview of all the differences between the order that's being presented now for discussion and the order that was adopted in November of 2021. I think Debbie went over some of the revisions from the versions that have gone back and forth for the past 2 years. But I think it might be useful for the public to understand how much this is different, how much has changed from what we first brought to you in 2021. Just a quick overview, if it pleases the court.
I don't know if that can be done in a quick overview.
I think I can do it in a quick way.
As a member.
This is my last commissioners court meeting and I've been
No,
working
I
on this for 2
understand.
years. So I'd really appreciate an opportunity just to give you a brief overview of what we've done together.
My thought is, this is a very critical ordinance that's been worked on a long time. I'm not in a hurry. I would like to hear your full thoughts on this.
I appreciate that, Commissioner. The tree committee has been great. They've put a lot of effort and time into meeting with me and with Elle and before Elle, Valerie, And a couple of times they've had to meet to visit with developers who had plans that would have required the removal of a significant amount of live oak trees. In 2021, the Commissioners Court adopted an order that we replaced an existing ordinance. And all of that is made possible by a special statute that was adopted by the state legislature in 2009. And that statute gives us special authority to regulate the cutting of live oak trees, even though most counties don't have such authority. That section is 240.909 in the local government code. It does give this county the ability to prohibit or restrict the clear cutting of live oak trees in the unincorporated areas of the counties. It further says that we can define what a violation is and that a person can be punished as a Class C misdemeanor violation with a possible fine of up to $500 for a violation of the county's order. Further, it provides that the county attorney or an attorney representing the county may file an action in district court to enjoin a violation or a threatened violation of an order adopted under this section. The reason I mention the statute is because it is different than what most counties can do. Cities generally have pretty extensive regulatory authority, more so than counties do. So Betty Stiles and others went and approached the legislature back in 2009 to point out that the live oak trees in Aransas County are a unique resource and should be protected. And that's how this statute came to be. The original order that was adopted, that was still in effect as of 2021, was very brief. It didn't provide a whole lot of mechanism for enforcement, review, or even provide definitions or procedures. So after looking at that with Valerie, we came up with an original order for your review in 2021. And that order did a lot of things. Until it was put into practice, however, we weren't really sure what might need to be adjusted. The tree committee had been defunct at that point, but in 2021, with the new order, it was revived and revitalized and members started participating again. So that was a really great step in the right direction, just having a committee come back into the picture and being involved. That order 0-12-2021 was our first attempt, and there were things that needed to be tweaked over time. Valerie and I first came up with a list of things to change within the first few months of that order being adopted in November of 2021. Since that time, the list has been adjusted a lot of times. We've gone back and forth. I'm not even sure how many versions at this point between my office and the committee and working with environmental health as well. But the final version that was included in the agenda packet was my final version with a red line comparing my final version to the order from 2021. What did not make it to the packet were some additional revisions the tree committee is suggesting that weren't sent in time for Tracy to put it in the packet. And that's why it will come back for you in the future. But those changes are relatively minor, the changes that Ms. Griffith went over just a few minutes ago. I just want to say that the definitions that she mentioned are in fact in my final draft, the critical root zone and pardon me, I've got to make sure I know I'm saying the right one here. There's another C definition. It was for critical damage. Those definitions are present in the final version I presented. What's not, however, was some of the language regarding what an environmental health staff has to do. The way it's written in my final version, the staff of animal care, that's on my brain too, obviously, but environmental health would come at least annually and give the tree committee information on how the ordinance or order is working and problems that are being seen and maybe suggesting that some revisions be made. The reason why I only said annually is because an advisory board's purpose is to advise Commissioners Court, not to direct staff, not to assign staff any types of duties or ask them to provide additional documentation that doesn't already exist in real life. Staff should not be creating records at the, I guess, reasonable request of the Commissioners Court, yes, but not when it comes from an outside entity that doesn't have any authority to direct our staff. So I did leave it really just at one time, at least once a year. Environmental health would do that. Would that mean that they can't do it more frequently? Absolutely not. If the Commissioners Court directed staff, or pardon me, Judge Garza directed his staff to do that, then that's something that could happen. I just didn't feel it needed to be in the order. As far as the reinspection does take place. If somebody cuts trees without going through the process, then our staff finds out We do have to go out there and take stock of what's happened. And then once the mitigation measures are determined, our staff would have to go back out and re-inspect the site. I did not put anything in there about us going back over a period of 3 years to do that because of staffing. Right now, we have very limited staff in environmental health. We don't have the ability to promise that we will have people to inspect periodically a whole bunch of different properties. So again, my definition doesn't require it be done periodically over 3 years, but could it be if we have the staff? Absolutely. It's just not putting something in the order that sets us up to potentially fail and not be able to do that. Other than that, all the changes the committee recommended, I think have been incorporated into the final order. One thing we've done is we've gone through and added a whole bunch more definitions to explain to people why the trees are important, how we're measuring the size of the trees, and what we're trying to accomplish by keeping as many of them as we can, while also recognizing that property owners have to have a right to do what they want with their own property to an extent that it doesn't harm others. And the idea being that the removal of all of our resource, all of the live oaks, would be damaging to the community at large and not just an individual property or property owner. So the reasonableness is what we look for. We would hate to see somebody remove more than 50% of the live oak trees on any given property. And that's what this order recognizes. In addition to that, it does have mitigation measures and mentions things like irrigation. On some properties where trees are going to be planted to replace some that have been removed, it might be necessary for owners to take additional steps like installing an irrigation system. The way that I've included it in the final order, it wouldn't be a mandatory thing for every single situation. It would be looked at on a case-by-case situation because some properties obviously do have enough water already to keep these trees happy and healthy because they live there already. The trees are already there. So it's not always going to be necessary, but this order does acknowledge that sometimes that would be required to keep the tree alive for any significant amount of time. Another thing that this order does is it includes a chart that shows, and you probably have it before you, I know it's in our packet, that shows where the different areas of the tree are measured. And it's a really nice graphic for you if you want to take a look. It talks about measuring them at 4.5 feet above the ground level to come up with the diameter at breast height. It also shows where the area of the critical root zone is and where we have to protect the critical roots. So this order would apply on properties that are at least 1 acre in size or larger. If a person wants to remove 50% or more of the live oaks, they would have to submit a tree plan to the Environmental Health Department and explain what they are going to remove and where, and go over the plan with staff. If staff looks at the plan and finds that it is reasonable, a tree removal permit may be issued, and the property owner would be able to go through with his or her plans or its plans. What we found over the last 2 years is that times developers just go ahead and cut the trees and hope nobody notices. So we have to trust on our community to report. If you see something happening on a property and there's no posted sign showing that they've gone through the tree removal process, please report it to environmental health so they can take a look. This is one of those situations where you see something, you say something, otherwise we will have very limited ability to actually enforce the regulations that we've adopted. If a property owner wants to do something that normally wouldn't be allowed, the property owner can request a variance from those requirements. The order does provide a whole bunch of information about what the variance procedure is and what someone would need to do in order to request those types of changes. There's also a figure 2, that gives you an example of cumulative calculations for removal. If a property owner comes to the Environmental Health Department and requests 50% of the trees be removed, and then later the lot is split, what do? Well, we still look at it cumulatively. So we will still look at the entire property as a whole. That means that if I have one big lot, I can't remove half the trees on half of the lot, divide it into 2, and now I have a lot with no trees at all. And think that I can now remove 50% of the remaining trees, which would now take it down from 50% to 25%. This order says you can't do that. We look at it cumulatively. It follows the property at those original lot lines. You can't get around this by subdividing your lots.
Let me ask you a question. on
Yes,
that.
sir.
If you can't subdivide it, how long is that? Because you may have 2 or 3 different owners in that particular lot, and then you want to subdivide it.
You can subdivide your lots. You can't subdivide your lots to get around the tree requirement.
What would be the evidence that would prove that?
The evidence
How
that
We
would,
do that?
I'm sorry?
I mean, how would we enforce that?
Wait, that's why this is a problem. And that's why it's taken 2 years for us to get to where we are today. There are a lot of problems with potentially, enforcing the order. What would be great in a perfect world is if environmental health had a record of every property in this county that says what its current state is, what kind of trees it has, where they're located on the property, what kind of health they're in. That's obviously not something that we can do. That's not something we can make owners do. But as people come to us and apply for a permit, the hope is that environmental health will be able to keep really good records of that and be able to refer back to them over the years so they can see what's happened with that specific lot or property over time.
Second question I have would be, we have a certain defined set for failure to comply, for cutting the trees that they should have not cut,
Are you talking about the penalties,
the penalties.
the administrative penalties?
Okay, now, how much of the administrative penalties and how much, if they were developing 100 acres or 10 acres or 5 or 2 acres, it doesn't matter. What is the financial emphasis
Sure.
for them to not just cut it and then just pay the court fine?
Well, there are 2 different things to look at first. There's the administrative fees that are completely separate and apart from a violation of the order. The administrative fees just pay for the county's cost to enforce this order. So you're looking at pretty reasonable costs. For example, $50 for pre-inspection, $50 for compliance inspection. For a tree removal permit, $55 plus $35 an acre. And for the fees after you've been removed in violation of the order, currently the version I gave you says $500 and $35 an acre. That's different than what you asked for. I think the committee asked for something over 700.
Yes,
But
we
my
asked for
worry is,
750.
right, but my worry is that the criminal penalty for a Class C misdemeanor is a maximum of $500. I can't imagine that administrative fee that's greater than the criminal penalty would be reasonable. Keeping in mind that an owner would be subject to prosecution through our local court for that Class C misdemeanor for up to $500 for every tree that's removed, depending on what we can prove, while the administrative fee is intended only to cover our cost of enforcement. So those are 2 very separate animals, distinct from one another, that are not always going to go together in time. It may take a while for the criminal case to work its way through court, while the administrative penalty can be put into place and collected rather quickly to help cover our cost of sending our staff out for inspections. Does that make sense, Commissioner?
Oh. No, it didn't answer my question at all, but.
I thought I did. I'm sorry.
If he's got 500 trees and it's X number of dollars fine per tree, yeah, that makes the difference.
Yeah, that's what it would be.
But it's not a fine per tree.
Yes, it is. $500 per tree if we can prove it. Each tree that's removed in violation of the ordinance, it could be a separate criminal penalty.
Yes, I'm sorry. I was looking at the ones up above the $50, but yes, if you can prove it,
That's right.
once it's been cut down
And we've had some luck
Yeah.
with that. One specific incident that happened in 2021, we had a developer who removed a lot of trees. I'm not going to mention the property name because I don't feel it's necessary to get that specific. But because of the number of trees removed and our inability to prove how many, we entered into a settlement agreement with that developer and had them pay a penalty as part of a civil agreement in lieu of prosecution under the current order.
But then they would be in violation of the administrative part of it.
They would, but so in this case, for example, a criminal penalty agreement might be $10,000 and the administrative cost would be $500 plus $500 plus $35 an acre, because that's just paying our cost to enforce. The administrative fees cannot be used to punish. They are not fines. That's what the criminal violation is for. Does that make more sense now?
It does.
Okay.
It does. And
So
just-
the criminal
because-
penalty can be significant.
Because, if I'm gonna go out and develop 5 acres, And I've got 3 oaks in there, and that's $1,500.
Mhm.
Okay. And I'm gonna spend $750,000 to develop it, $1,500. You know, if I forget to do that, it's just, or I don't do it.
Well, it's
or
not
I
that
don't want
people
to.
forget, and that's the main thing that's important here. We want to make sure everyone knows that this order is in place. It's been included in our building permit process for 2 years. People know, developers should know, realtors should know, property owners should know. It's not that we're ever going to be able to charge them enough money to make it more expensive than it is profitable. That's not possible, especially in commercial development. So Commissioner, while that is a very valid point, what we need to get to is a community attitude that this saving of the trees that we can save that are healthy is more important for our community, and work together to try to make sure we're enforcing this order. We're never going to be able to make it expensive enough. Like we can't charge them $750,000, for example. We can't make it painful enough for them to not do it without the help of the community and the change of attitude.
The point that I'm getting to is that we're not doing this to gain money for the county. That's not
Absolutely.
why we're doing this.
Right.
What we're doing for this is to protect the long-term value of Aransas County, the long-term attractiveness of Aransas County, and the long-term utilization of the property in Aransas County. This is not a money-making issue.
It is absolutely not to make money. And I think the committee would tell you that they would actually prefer that that we charge more in the way of fees than what I've suggested that we charge. And again, I limited my suggestion on the cap for the tree removal fee for a permit issued after they violated the order be capped at what the maximum criminal penalty would be for the removal of a tree, which is $500. That's just to help pay for our cost of staff. It's not for us to make a profit. I guarantee you that. As far as the criminal penalty goes, that goes into the same place all other criminal penalties go. It's not funding us. It's not a way to make money. But again, when somebody violates the law, there has to be some kind of financial penalty.
Right.
And a Class C is limited to $500 per offense, and there's no jail time, but $500 per each tree if we can prove it.
Yeah, and I might like to add with that, at the last presentation I made where I gave some statistics, going back over the last 2 years, most people went ahead and it didn't go to criminal court and they paid about $250.
That's
per
between
tree.
the prosecutor
Yes, I know.
and the offender and the court. So all we can do is, as a commissioner's court, all you can do is set what the maximum penalty is. And then what happens after that, it's just like when the legislature says in this statute that gives us the ability to regulate it all, we can charge them with up to a Class C misdemeanor, but we're limited to that $500. And then whatever happens in court, none of us can control. Whatever happens once it gets to the prosecutor's office, only the prosecutor involved can control. So that involves a good communication between environmental health and the county attorney's office to make sure the cases are as well documented as possible so they can move forward. Sometimes cases are settled for less than what the maximum penalty is, especially if there's an issue maybe with the photographs. Maybe they were lacking photographic evidence that they would have liked to have seen to go to trial. So instead of that, they settled and asked for them to pay a smaller penalty. But that doesn't mean that they're not paying a penalty. And the more that we see this happen, the more it'll get out in the community, and hopefully the fewer violations we'll see.
Well, once we file, it's up to the court to determine the fine anyway, up to the maximum that's set either by the court
Or if
Yeah,
there's a
I mean,
plea
that's
agreement,
out of our jurisdiction.
that's true. Or if there's a plea agreement, the prosecutor's office would.
Whenever we first did this, we had a lot of violations. And we understood that. We knew going in, we were going to have a lot of violations. It doesn't seem that we have that many violations anymore. It seems like everybody's
No,
aware of it.
that is not the case. There
That's
are
not the case?
violations. That is not the case, sir. There are violations basically with every property that's been developed. There have been some form of violation. Most of the time it is just maybe they aren't removing too many, but they're not getting the permit, not going through the review process.
Okay.
So we definitely needed to have a public awareness campaign with this to make it more widely known. And the tree committee did put out a big banner over by McDonald's for Arbor Day that has a really attention grabbing photograph on it of a lady with a chainsaw. And it says, call before you cut. And that is the idea, that you come talk to environmental health and figure out what the requirements are, how it applies to you. And it's a nominal fee to do it right. So let's do it right.
The part that I struggle with this whole thing is, as a property owner, I feel like I own the trees on my property. And I think that's a common thing with people that own property. And to me, we're getting so into the weeds on this thing that we're pressing on maybe creating a taking. And where we'll have to pay the people for the value that we affected their property.
So the biggest fear I have is overregulation and overregulating ourselves into no longer having any authority at all. Our governor has been very vocal over the past several years about the dangers of overregulation and specifically about regulation of trees. So we kind of know, at least from Governor Abbott's standpoint, that he kind of frowns upon regulating this area. The legislature gave us some limited authority to regulate, and that's what we're trying to do. Reasonableness is the main thing that we have to look for. What you're suggesting is that if we overregulate, we could remove someone's most economic beneficial use of their property, which would result in an inverse condemnation case or a unconstitutional taking, basically keeping them from using their property the way they want to by our regulation. That's a valid concern. It's a concern that I have, and I think that anybody who's familiar with inverse condemnation would hope that we are staying so far into the reasonableness area that we wouldn't have to worry about that. And I think the variance procedure gets us there because we can have people come and request a variance to do something else, that they can remove the trees, do what they want with their property and mitigate some other way. So there is a way to allow the property owner to do what they want while still following through with what our mission is, which is protecting that natural resource. That was a lot of words.
Yeah. And one of our primary goals too, if we could, we would have distinguished between commercial properties. So remember, it's 1 acre or above. And what we're seeing most of the violations is with larger acreage. And if we could, it would have been nice to be able to separate between commercial versus residential or such. But we don't have that ability here in Texas.
So wouldn't that be discrimination?
No, it wouldn't be, but we're also not doing that.
What I would say is when I first came onto the court, I was very concerned with what I saw going on in the community, and I knew how hard Betty Stiles had worked back around 2008, 2009 to get that first tree ordinance. And worked with her to get it reestablished, get some teeth in it, get a new active committee appointed. This committee has worked almost obscenely to revise the order, and first with Valerie and then with Elle's cooperation and with the assistant county attorney, whose son is a forester, and she also shares a passion for trees. I think that this order that we have before us, and I have read them all, I am not intimately familiar with all of the details, but when I read this one that was in our packet, I thought it addressed most of the concerns we had at our last meeting. And I agree with what Ms. Osteen's saying. If a class C misdemeanor is capped at 500, we cannot assess a higher fee than that.
Right. And we agreed to that completely.
Okay. And I wonder if hearing what she said today about her responses to making some of the changes that you just talked about, can we vote on this today?
Well, right now your motion was to discuss.
I know. That's what I
So you could amend your motion if you chose to do so. I did kind of say this at the beginning, and this is an important issue. I have worked with the tree committee, and really it's been about 2.5 years that I've worked on the first version of the order and then all of the revisions on this second order. It's important to me to see it through, and this is my last meeting. I would really appreciate the court's consideration and potentially adopting the revised order today. I hope I've addressed the questions that were brought up by the committee and explained why I didn't want to make those extra changes, but virtually every other revision they've asked for is included.
And I would like to go back to Bubba's comment.
Would you identify yourself, please?
Shelley Steckler, I'm on the Aransas County Tree Committee, the City of Brockport Tree Committee. So the order only applies to an acre or more. And when they apply for their tree permit, if the tree is in the boundary line of their septic system of their home, then that tree is able to come out. And if later on they want to put in a small building or something in the back, as long as it's permitted, the tree is able to come out. So this is to protect the trees from basically being clear cut. It applies to 50% or more. So it's not like we're actually saying, no, you cannot, or you can't do anything to your property. That's not the case, and that's not what this order does. And if it's a bigger development, what I would actually like to see, I know we cannot differentiate from commercial and residential, but in the city we can. And what, if it's going to be, we have an 84-acre subdivision coming in off of Corpus Christi Street. I've seen their tree plat. I cannot differentiate what trees are on there, what size. But in a later order, I think that with so much development coming into Aransas County, we have approximately 24 subdivisions. So if we are not protecting our natural assets, our trees, which actually cool the temperature of where we live, they give us triple the price point of our land value. They help clean our groundwater. What are we going to have in 20 years from now? We're going to look like Portland, and that's not what your community would like. So moving forward with this order and this adoption is for the betterment of our community.
Hey, Shelley, the difference on our opinion, you stated real plainly. You said our, I said mine. That's the difference. You see that all of the trees on everybody's property as ours. We, the property owners, see them as ours.
Which is
That's-
why,
That's the difference.
and that's why we have that variance procedure, because we want to ensure that whoever invests in property, whoever owns property can use it the best way that they know how, the best way they choose to. So we can't absolutely prevent someone from changing their property. We just need to have a procedure in place, which we do, for them to request a variance so that they can still do what they want with their property. It may involve them planting trees at a different location to make up for the trees they're removing on their property. And this really is about clear cutting. It's not about the removal of one or two trees. It's about clearing out a property that is currently somewhat forested and wiping it all out, which is what we were seeing a lot of at the time.
Well, and the other thing too, is this deals only with the unincorporated area.
That's
It
true.
does Not deal with the city.
That's true.
Right.
Unless we move into some sort of agreement with the city, this doesn't touch.
We wouldn't be moving into an agreement with the city because they have greater regulatory authority than we do. So the requirements within Rockport city limits or Fulton or even Aransas Pass could be totally different than what they are here in the
Jen
unincorporated
provided very
areas.
good information and everything to us so that we did understand that, because originally at the outset, we wanted greater penalties and smaller acreage, half an acre, 3/4 of an acre,
Yep.
40% of the trees instead of 50, but she educated us very well about really what the limitations were and why.
I just want to make sure that public understood, we're talking about the unincorporated areas.
Right.
We're not talking about the city areas. What the city does, of course, the city has more authority than the county does in private property. I just want to make sure that was very clear, because we have some properties that are developing both in the city and the county both. And it's pretty confusing sometimes.
Yes, I'm sure it can be. And Mr. Castellan, I just wanted to mention too, I've attended in the last 2 years several variance meetings. And in those meetings, I think the tree committee and environmental health, and I think we're very balanced at understanding what their needs are and actually come up with some suggestions, trying to make it work for them. And that's been very evident in the variance meetings, kind of discussing alternatives that they might not have considered. So, but I agree with Jennifer, and you really explained the order very well.
Thank you.
And yes, we would love to go forward because there's a lot of communication to do. We don't have a budget for that, but we would like to, we have a strategy. Let me put it that way. We have a strategy and we'll do as much as we can. And updating the information and all the paperwork that's in environmental health, I've offered to help do that, to take the burden off of them. And we'd love to be able to get this out there.
So I will rescind my earlier motion and move to approve order O 27-2023 An order of the Commissioners Court of the County of Aransas, Texas, replacing Order 012-2021 entitled Regulations for the Cutting of Live Oak Trees in the Unincorporated Areas of Aransas County, to retitle the order Regulations for the Removal or Clear Cutting of Live Oak Trees in the Unincorporated Areas of Aransas County, to amend definitions and procedures, to provide for severability, repealer, and savings, and to establish an effective date.
I'll second that, and I would like to, if commissioners are able to say, as approved by the city attorney or by the county attorney.
Well, that's the version we have in our package.
Yes, approving the version that's in the packet.
So is the version the one you'd went through, or are we voting on having the additional changes?
The
that were
version that's in the
suggested?
packet is the version I was presenting to you that incorporated all of the changes except for a few that Ms. Griffith went over and then I responded to. So it would be the version, the only version that's in your packet that was available to the public on our box and that they can look at any time. So without those few changes that we talked about.
It's a 13-page document, right?
Well, I think some
Yeah.
things need to be changed just because the numbering
Well,
issue.
perhaps
No, I think, I mean, I looked at this, Debbie, while you were saying that, and it seems like the numeration works.
I
Okay,
don't think
maybe
that
it was
there's,
changed by
I think it
Tracy.
was the red line version you were looking at, Debbie. I think it was kind of confusing. There is no numbering problem in the final version that I can see.
Yeah.
But of course, that's something that's not substantive in nature. So if it did come to be that
Yeah.
upon looking at it, there was a numbering issue, we would correct the numbering issue.
So I do have one question.
Yes.
On page 7, under section 7, under subsection tree plan C, I think there's a missing word in that second. So it says an approved tree plan containing a tree survey site plan, any applicable mitigation measures must be fully utilized and the complete before it expires. I don't know what that,
That's something that I had corrected in the version that I sent to
but
Tracy
what should it say? Should it say the complete
and completed.
and completed? Okay.
Yeah.
So that's minor, very minor.
Yeah.
and also, was it changed where it reported to environmental services?
Yeah, it was a little more passive. It was just saying that upon request that we could request it from environmental so that we could monitor utilization and trends.
But my concern with that is again, that advisory committee should not be directing staff or giving them more work to do because they're already very busy, but that of course our staff should be providing statistics at a minimum annually, so it can be reviewed along with the order annually.
I think
That
you
doesn't
can-
mean that Judge Garza couldn't ask it to be done or that the environmental health department couldn't volunteer to do that more frequently.
Yeah, I think you can request without it being spilled out in order.
Because in what we would be voting on, it would say what you said, Jen, that environmental health will provide the tree committee an annual report that will include a number of items. And I think that's good.
All right, we got a motion. We got a second.
I think
We are approving what's in the packet. Any further
Commissioner
discussion?
Cheney?
Are you through?
Yes, sir.
Yes. Aye.
Commissioner Casterline?
No,
Commissioner Russo?
Aye.
Commissioner Dupnick?
Aye.
Judge Garza?
Aye. Passes 4-1.
Thank you.
Thank you, ladies. Move on to item number 9. Thank you, Debbie. Do I have a motion for item number 9?
move to approve change order number 11 for the construction contract between Aransas County and Teal Construction for the construction of the new Aransas County Courthouse, resulting in an increase in the contract cost of $6,893.70 with no changes in the length of the contract and further consisting of the following changes. One, CRP 72 furnish and install security grills, cost increase $2,536.60. Number 2, CRP 75 furnish and install stainless steel cover plate with tamper-proof screws for the card readers at the detention area in the new courthouse. Cost increased $220. Number three, CPR 76, furnish a new circuit and switch for additional RFI 203 water heater. Cost increased $4,137.10.
I'll second that.
Got a motion, got a second? Good morning, Mr. Strothman.
Good morning. These are just a few small change orders that came up as we're going through the process.
Were these in the original bid or were they just missed?
Some of it was missed. The breaker was missed, the cost, the installation of the security grill. The Jail Commission has asked for the grill to be changed to a different type of grill. And the $220, the security doors were spec'd out to be keyed doors, not electronic doors.
Right.
So what you said about the security grills,
Correct.
repeat that again?
The
criminal
grills that were spec'd in the building were not what Texas Jail Commission approved. So they had to be changed out.
And that was a design?
That's a
issue?
design issue, yes.
And don't we have more of that to come?
Yes, we do. Sizably more.
Yeah.
John, are those the security grills that are in the inmate areas of the courthouse?
Yes,
So were those secure areas on our plans?
yes,
So should it have been assumed that they were security grills?
yes.
Thank you.
And, you know, I know that there's always change orders and
Yes.
this may be an inappropriate time to bring this up, but on things that were on the plan and were missed and things that should have been there that were missed. Changes, I understand, your measurement off here or there, but change orders are really getting kind of old. And I know that we set money aside for that, everything like that, but we pay the construction people and the designers and everything good money to bring us a product that on paper is correct. And then, you know, I realized we had problems with the generator. That was not anybody's fault. It just was, with the generator and the transformers, they were all holdups because of market issues and everything. But it seems like right now we're down to the nitpicking, and that's things that, you know, I'm an electrician, and if I miss a switch, I pay for the switch. You know, if it's on the plan and I miss it, I pay for it. If I don't miss it and it's not required at the time I submit it, but something changed to make it so, then I don't pay for it. So I just, it seems like we're a long ways behind on this because of market issues and things like that.
Mhm.
And it looks to me like they're nitpicking us to death. Anyway, my thought.
John, do you have a copy of the document we have?
Not in front of me, no.
Okay, because it shows the original contract sum of 23,615,000. Then it says there's a net change, previously authorized change orders. We had a credit of over 74,000.
Yes.
So that's a credit in change orders only, right?
That's what we have left in our credit. We have a credit left. We're still operating with credit money.
Okay, so because after this change order, it shows we still have credit then of $67,754.
Correct.
So that's still credit we have left.
Credit to us, yes.
Okay, we need to explain what that means, though. The credit
Yes,
was
please.
based on
That's what I'm
value
asking.
engineering. So the original contract price was higher than expected. And so the engineer and architect and staff got together to try to bring down some costs that were more in line with what our original estimate was. So there was we're going to call that the credit. So right now we're chipping away at the value engineering credit
That
where
is
we're
the value
almost all the way
engineering
back to the
credit.
original bid.
Okay.
Okay.
Okay, thank you. That is the value engineering credit.
Yes, sir.
Okay.
Yes, and then other things that we have gotten credit for over time, over the process.
Okay, thank you.
And the question on the CPR 76, the additional hot water heater not
Mhm.
shown on the electrical plans,
Correct.
was that a water heater that we didn't anticipate needing? Or we knew we were going to need it, it just wasn't on the
The
plans?
breakers weren't on it. The breakers weren't on the plan.
Commissioner, the water heater was on the plan, just not the
Right.
electronics that go with it or electrical.
Is that a
systems with it.
design issue?
That's a design issue.
Okay, thank you, sir.
All right. Thank you.
Commissioner Cheney,
Reluctantly, aye.
Did somebody second that original
I
motion?
did. I'll take it.
Jack.
Thank you.
Commissioner Cheney,
Reluctantly, aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Nay,
Commissioner Dukenyak,
Aye.
Judge Garza.
Nay. Passes 3-2. And move on to item number 10.
I move to discuss, approve, and disapprove the county, Aransas County issuing a request for proposals for Tiger Field Athletic Complex, RFP 2023-1105, located at 1301 North Live Oak, Rockport, Texas.
Second.
Got a motion, got a second? And this,
do we need that motion though to be more direct to say move to approve it rather than move to approve or discuss?
I would move to either approve or to disapprove the issuance of the RFP. I would pick one.
can you,
Do you want to
Do you want to?
restate
Well,
that, Commissioner?
I'll do that for the point of discussion, so we can figure out what it is, okay?
okay, so we're discussing it first?
Discussing it first.
Do I have a second to discuss it?
Second.
All right, we got a motion, got a second. So this is, I guess Tiger Field is something, we all know what Tiger Field is. The past few years, we've always had like nonprofits manage Tiger Field for youth sports, for different organizations, for different events. And so after I took office, I had a lot of people inquiring about, that they want to take over Tiger Field, basically. And currently we have someone managing it, but he's not under any contract. I guess in the past, it's always been the judge said, here, you could have it. But we're going to try to do things differently. We're going to try to get into a contract. This is what this is for, proposals. There was a lot of people that want it. So this gives them an opportunity to put in a proposal. I believe the city even wants to propose. But anyway, that's what this is about. If you have any questions, I'll be happy to answer.
If the city has interest in this, would they have to follow the same proposal or would
Yes,
they
sir.
ask for alternative?
Anybody who'd be interested in running Tiger Field would have to submit a proposal that would be evaluated against the other proposals. I want to build just upon for a moment what Judge Garza said. Currently, we don't have a contract that sets forth the obligations of the parties. And I think that's really important that we do that moving forward. If a group comes in and is using our property for any use, be it profit or nonprofit, the county shouldn't still be paying the bills for them. For example, we shouldn't be paying electricity. If a group is using the property, then they should be paying the utilities. That's just my personal opinion. And the court may decide to do something different when it comes down to actually entering into a contract. But it's a good idea that whether you choose to have them pay for it or not, that there's a contract that says who is going to pay for it and who is going to pay for insurance, who's going to pay for property coverage and liability coverage. And if there are concessions, who gets the money from concessions? So there are a lot of issues that should be addressed in a contract. So I would ask that you do please consider issuing this RFP.
I just have a couple of questions, and I'm not sure if this is just a sample of what we might issue or if this is the one that we're going to issue. But there were a couple of discrepancies on page 12 and 20 when it's talking about the liability insurance.
As you're speaking, I'm looking at Eric
Okay.
Smith, who's our contracts.
So I don't know if Eric wants to come up to the microphone.
He was nodding his head that this is just an example. Before it goes out, we will give it another final look to make sure that there aren't discrepancies. But we would ask that they have liability coverage.
Oh, right.
And before we enter into a contract, that we would require that they show us proof of that.
No, I think that's a wonderful idea. It's just that in some of the places it talks about $200,000 and it has it in text. And then in parentheses, it shows the numbers, and then 400,000 and it does the same. But then in third place, it says $200,000 in text, and then in parentheses, it shows 400,000.
That will definitely be corrected before it goes out,
Okay.
but thank
and-
you for mentioning it.
And that was page 12 and then page 20. And then on page 17, 18, and 19, there are several references to aircraft and hangars. And so I just would request those would be struck. And I understand using a template, and I'm fine with using templates, but just so that's not in the one that then is brought to court.
Uh, I like the idea of private entities, running it. But that unfortunately comes with a pretty bad stigma with a lot of things that the city or the county has dealt with, and I know the city's dealt with it too. Is once you get these people in here and they're not following what they're doing, how do we get them out? And now the other thing too is we work very well with the city, and I would like to see if the city would meet our proposals, if they'd be given an opportunity to take this without going out, because we work real well with the city. The baseball is normally a city deal. It's not a not-for-profit thing. If there is a profit, the county should get its share in there. But where we've worked with the city before, for the most part, has always been good.
Anybody who wants to submit a proposal will be able to, and that would include the city or any organization that exists or that would want to become an organization in order to respond. It could be that there's a group of citizens that think that this is a reason to get together and form a new group. We'll see what happens once you issue a proposal, but noting too that part of the problem with not having a contract is not having any idea what people are supposed to be doing.
I agree.
What are their duties and obligations? If they're using our property, they should be reporting back to Commissioner's Court, tell you what they're doing with the property, just like everybody else who is given tax dollars to come and report to you what they're doing with that money.
Well,
Same thing.
Since we're not selling the property,
Yes, sir.
there's no capital gains there as far as capital improvement there, but I would suggest, my suggestion would be to go talk to the city, tell them exactly what we need and everything, and let them have an opportunity to enter into an interlocal agreement. And then we don't have to do a lot of this stuff, because we're not selling the property. We're
No.
just negotiating the use of the property.
Now, one option for the court today would be to not take the vote and just keep the discussion portion of the motion that Commissioner Russo, or pardon me, the Commissioner Cheney made was just for discussion anyway. And that way staff would have an opportunity to contact the city and see if there's any interest there. And then if not, Eric Smith could come back with another RFP with making the corrections that Commissioner Russo pointed out for your consideration and approval to issue an RFP.
Well, and I'd be willing to make that motion, or
You already did,
revise my to revise my motion to.
No need. You already made that motion, sir.
Okay, well, I think we're a growing community. The city's going to be doing more and more things. And we are charged with the unincorporated area. That's not an unincorporated area.
Well, it still is our property, though.
It's still our property. Well, the courthouse is our property too.
That's right.
But I've worked with the city quite a bit over the 16 years or so that I've been here, and with school board before then. And we hadn't always been smooth, but it has always been congenial, and we've been able to work through the issues.
I think it's something we could talk to him about, and Judge Garza could reach out and see if there's any interest on the city's part. We haven't actually talked about that, that I know of, but it's possible that they might be interested, or someone over there. Of course, they may easily say that they're already involved in a lot of other projects and they would prefer that we reach out with an RFP. But
I think we should do the RFP. The city can make a proposal to whatever they want to do with it. I don't think it's right to cut members of the public out to make a proposal to use the property.
you never know what someone's going to propose until you give them an opportunity to tell you what they think you should be doing with your property.
Because
They may have a
people
great
send in-
idea.
People send in their proposals. We have the opportunity to to review them and come up with an agreement between the ones that we pick. And all that.
Any further discussion? All right, so right now on the table, we have discussion.
Do we need another motion?
Yeah, can we vote on
to
that then?
provide
Yeah,
direction?
let me revise mine to, would say that we would approve going out for proposals with allowing the judge the opportunity to review them and bring back to the court the top proposal.
Got a second?
Second.
Got a motion, got a second. Let's go and vote.
Commissioner Cheney,
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 11,
I move to approve the proposal from Co-File to change the style of cabinets approved in the March 1, 2022 contract. This is due to the manufacturer no longer making those quoted cabinets.
That's a good reason. Second.
got a motion, got a second. Ms. County Clerk?
There
Morgan?
is no change to the budget at all. It's going to be the exact same amount, the exact same services. It's just a different cabinet.
And will it work as well for your office?
Absolutely.
Okay, good. Thank you.
Easy. All right.
Make a motion to approve.
You already did.
Already
Oh,
done.
it's already been made. I'm sorry, excuse me. Excuse me. Woke up.
Commissioner Cheney,
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 12,
Move to approve declaring as surplus 5 iPhone SE second generation and 1 iPhone 7 and selling them to used electronics resellers with an estimated value of $318.
Second.
got a motion, got a second.
Is that the total or a piece?
That's the total
Okay.
estimated value for them. We are trying to get away from bulk surplusing of items and trying to maximize the return on what comes back to the county instead of pennies on the dollar. That's some of the items I've been getting in the past. So where you have a bunch of iPhones that have been sitting on a shelf collecting dust, and so we're going to try to sell them to electronics resellers and that recycle and can you take them apart and use them for parts and other things, but it'll give us a better value than just
I
selling
think,
them for 50 cents in a trailer with a bunch of other junk.
I think that's a good idea, except I think that probably needs to be approved by the Commissioner's Court since it's county property.
And
That's why it's-
why
That's
it's
what
on
it's
the
on.
agenda right
I'm
now.
sorry. I think the policy needs to be approved because we've been doing it. And I think that's a good way to do it. I just think we need to bring that to the court.
Commissioner, every time we declare a property surplus and authorized disposal, it has to be approved by the court. Normally, though, we have a list of property that you declare surplus and authorized disposal. What Colin's done is he sought out better pricing for just 2 specific items. But normally, we would probably still bring you a list of various items to declare surplus and then get the best pricing that we can.
Okay.
And Colin, I think this is commendable. I'm glad you're doing that. It sort of follows what Renee's been doing with a lot of the recyclable material and scrap. I'm just curious, for whom does the county provide cell phones?
So currently we have cell phones in the county attorney's office and our veterans office. And I think we have some at the sheriff's office that they've provided their own people for controlled use.
Not everyone in our office has one, just a few, specifically the prosecutors.
I'm gonna say the sheriff's office doesn't have.
They
The
do not
sheriff's
have
office
them
doesn't.
anymore? Okay.
Our office does because we have victims and witnesses that often have to call our staff after hours and on weekends to arrange for meetings and interviews. So we do have a few people in our office who have phones provided by the county, so they don't have to give out their personal number to members of the public.
Thank you.
All right.
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 13,
I move to approve authorizing the county judge to sign necessary documents to renew the GOVSOS seamless documents contract for another 1-year term with no change in cost.
Second.
got a motion, got a second. Mr. Jackson.
So this is our annual renewal for our electronic forms processing seamless docs that do the animal control license forms. It does also their adoption forms. It does our public information request form, or not public information request, but participation form for Commissioners Court. And this is just an annual renewal that we do for that service.
And it was in the budget.
And it was in the
Then, yeah.
budget. We are approving the contract. We won't actually get a bill for this until January. So
All righty. Any questions?
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 14.
I move to approve the county judge to rescind an amendment number 5 request for the General Land Office Community Development Block Grant dash disaster relief number 20-065-098-C270 grant and resubmit an amendment on the advice of the GLO grant manager for a more favorable approval outcome.
Second.
Got a motion? Got a second?
Yes, we had a meeting with GLO last week, and this was a recommendation by Genesis Webb, our grant manager with GLO. I have asked Anthony Gonzalez to be present, and he's on Zoom if y'all have any questions for it. This would separate our street budget amendments that we're looking at as from our Basin 39. Because that one's going to take a little bit longer to get through the amendment process. They felt if we separated them into two separate amendments, that it would make our budget one go a little bit faster. But if you have any questions, Mr. Gonzalez is on Zoom.
I'm curious what the Basin 39 project is.
So
The drainage that goes across 1781, kind of between where Pearl Point is and where and 3036 to enlarge, put box culverts in there instead of much bigger than the ones that are there. Doing some work on the drainage ditches that goes from there to Salt Lake. It was previously in a city grant, and the city cut it out for lack of funds. And so we talked to them about taking over the grant, and the GLO is looking at letting us do that.
So we're moving a project that was the city's, did you say 1781 across 3036 to improve the drainage along there, and the county's going to absorb it and cover it with our grant? What's the anticipated cost
I
of
was going to
it?
say, David, because it's already our project, isn't it? Or
This has already been approved by Commissioners Court, this project. We had extra money from our grant. There was only a certain things that it could be used for. This was something that was eligible. So we brought this to the court, I don't know, months ago, and it was already approved.
What's the estimated cost?
I can't recall. It's
About $1.3 million for construction, engineering, and environmental and admin services.
So this is just basically paperwork issue.
yeah, I mean, this
part of it,
is
yeah.
to speed up part of that amendment,
Right.
yeah.
And it was previously a project that the drainage committee and district had on their list of things to do, just that the city had originally put it into one of their grants, and when it fell out of there.
It was part of the stormwater and floodplain plan? Okay. And what did you say was the name of the grant administrator with GrantWorks?
her name is Genesis Webb.
Okay, so Genesis is the first name?
Yes, ma'am.
All right, thank you.
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
aye, passes 5-0. Item number 15.
Move to approve the October 2023 treasurer's report.
I'll second that.
Got a motion, got a second, Madam Treasurer, good morning.
And the report before you is the fund cash and investment balances. I would entertain any questions on the numbers.
Doing a good
Thank you.
job.
Thank you.
Commissioner Cheney,
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 16.
Move to approve the budget line item transfers for the 2023 budget.
Second.
Got a motion, got a second.
We have none at this time.
All right.
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. Item number 17.
Move to approve accounts payable liability.
Second it.
Got a motion, got a second.
Yes, sir. These accounts payable and payroll are normal payments. I would like to point out several that are different. On our capital projects on 430, we have Mott McDonald for $420. This is our Cedar Bio project. We're currently where they're just doing the monitoring for this last year, and then that project will be complete. We have an invoice from Gray and Pape for Lamar Shoreline project of $10,304.50. We have several invoices, 3 from Grant Works on 3 of the GLO street projects, street and drainage projects, totaled $147,479.75. An invoice from KC Lease for Copano Heights project, which is one of our drainage projects, $621,871.71. LCR Transport, which is they're doing the 1781 Street project of $230,090.78.
Jackie, could you say again, LCR Transport, what was that job?
It's 1781.
Okay, thank you. That's random, isn't it?
DLF is doing the community building, and that's $103,024.94. We also have an invoice from Teal for the courthouse of $400,221.52. They also wanted to point out, we have 4 invoices from Lloyd and Gosling that was $97,355.75. And I have those for you to sign. I just wanted to point those out because they were not in the budget, and we're going to be looking at having to do a budget amendment for those. Do you have any other questions? I'd be happy to
We had
answer.
spoken earlier, the money being paid to Teal,
Yes, sir.
that's not budgeted either, though, is it?
We have it in the budget. It's budgeted. It's going to be into fund balance. We do not have, we've used all of our funds that we've got from FEMA and from the bond issue that we sold. We are currently in fund balance. And as I have told y'all previously, if we do not receive insurance funds, FEMA will come back and reimburse us up to the $9.9 million. But I'm sorry. Yes, it's another 4 million. They've already given us a 5 million. But we have to complete the project, and then if the insurance has not reimbursed us any money, they will reimburse us. But it has to be at the complete end of the project. It has to be complete.
So any payments now will be coming out of the general
Anything
fund
now is
balance.
coming out of fund balance. Yes, sir.
There are no further questions. Let's go and vote.
Commissioner Cheney,
Aye.
Commissioner Casterline.
Aye.
Commissioner Russo.
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
Aye, passes 5-0. At this time, we'll hear reports from commissioners, elected officials, and department heads. No action will be taken. And I want to take this time, wish Mike Gear a happy birthday.
Happy
Yay.
birthday.
But we won't see.
Did y'all want to sing? Okay.
Well, we could sing.
No, no. And then also, Jen said this is her last meeting, so we wish you well. Thank you for your hard work. Thank you for everything. Learned a lot from you. Yep. Don't change your number.
I appreciate you putting out that memo about the county not having a noise ordinance, because there was some social media comments out there stating that the county had a noise ordinance and there was actually curfew hours. So thank you for doing that.
All right.
I wanted to take a moment to thank our blanket lady, Elaine McCollum, who brought us another 3 bags of blankets for the kiddos that are for anybody really that needs blankets. We're approaching 2,000 blankets that have been given from a Lavernia resident and her group. Everything. I think that's really special, and I appreciate Mike putting an article in the newspaper for that. That is strictly a labor of love, and we can't thank her enough. I don't know how many of those are still here or how many have gone out, but it's made a huge difference. And thank Miss Lori, and I also want to thank Alma for kind of heading that up. It's something that we started, I guess, about 3 months after Harvey or something. Been going on, and we're now, like I said, approaching 2,000. That's a lot of blankets.
All right. Anybody got anything else? We'll move on to reports about items of community interest. No action will be taken. Is this for y'all? Nope. All right. We will be heading into closed session. Do I have a motion?
I move to convene into closed session to consult with counsel and receive legal advice about insurance matters related to Aransas County's projects and insurance claims from Hurricane Harvey, including the following pending litigation. 1, Aransas County, Texas versus Endurance American Specialty Insurance et al. Aransas County District Court cause number 23-0021. And 2, North Star Recovery Service, Inc. versus Aransas County Independent School District and Aransas County. And Aransas County District Court cause number 23-0066, consolidated with North Star Recovery Services, Inc. versus HRNR LLC et al. Aransas County District Court cause number 20-0129, 20-0159. And 3, Aransas County versus Kathleen Hicks in her official capacity as Director of the Regional Pool Alliance. Aransas County District Court cause number 23-0069, pursuant to section 551.071 of the Texas Open Meetings Act, which authorizes closed sessions for a governmental body to consult with its attorneys regarding advice on legal matters pertaining to pending or contemplated litigation.
Second.
Got a motion, got a second. Let's vote.
Commissioner Cheney,
Aye.
Commissioner Castelline.
Aye.
Commissioner Russo.
Aye.
Commissioner Dupnick.
Aye.
Judge Garza.
All right. We're gonna have a 5-minute recess. Meet you back here.
Okay. Hey, Al.
Oh, and I voted against it too.
Sitting there going, counting, I said, okay, make sure you get this right, then I went.
You want to reconvene?
Yep.
I move
Uh,
we reconvene into open court at 11:12.
Got a motion? Got a second? Let's go and vote.
Commissioner Cheney,
Aye.
Commissioner Casterline, Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
All right, passes 5-0. We're back in open court, open session, and we have nothing further to discuss. You know, I'll entertain a motion to close.
Second.
All right. Got a motion? Got a second?
Commissioner Cheney,
Aye.
Commissioner Casterline,
Aye.
Commissioner Russo,
Aye.
Commissioner Dupnick,
Aye.
Judge Garza.
We are